At the conclusion of this lecture, you will understand the division of the English court structure and the structure and operation of the civil courts. One of the principal functions of the English courts is to operate different systems of justice which are distinct according to the area of law they deal with and the court procedures employed. A fundamental distinction can be drawn between the criminal and civil justice systems. Broadly speaking, the civil justice system enforces civil law in the civil courts using its own internal civil procedure rules, whereas criminal justice system enforces the criminal law in the criminal courts using its own criminal procedures. The civil law is a form of private law because it governs the relationships between individuals in society. For example, contract law, planning law, and company law. The usual scenario is that a claimant will sue a defendant, hoping that the court will decide liability in his favor. The court has to make a decision on the basis of what is known as the balance of probability, where an assessment is made between what is the most likely version of the facts of a case. The role of the state in relation to civil law is to establish the general framework of legal rules and to provide the legal institutions to operate those rights. Civil law is strictly a matter for the individuals concerned. The state will stay out of civil proceedings and will not be represented in the civil legal proceedings unless it affects the wider society. For example, in a dispute relating to the construction of a nuclear power plant. In terms of how civil cases are presented, they are referred to by the names of the parties involved in the dispute, for example, Smith versus Jones. The main aim of civil law is compensation for the person that has been wronged, and to restore the claimant's position as best as possible to the situation he or she would have been in had the loss not occurred. This is normally achieved through the award of damages to the claimant by the defendant. There is no jury in civil cases, apart from a few exceptions. For example, in defamation proceedings, the judge awards and decides on the appropriate level of compensation. Examples of civil law cases include matters relating to contract, tort, and trespassing. Civil cases are heard principally in the High Court and the county courts, where allocation usually depends upon the size and the complexity of a particular case. A tracking system is used to decide the appropriate court. The small claims track is a simple and formal way of resolving disputes. Here, there is no requirement of separate legal representation. The amount of the dispute cannot be more than £5,000. More complicated cases can use the fast-track procedure. The amount in dispute must be more than £5,000 but less than £15,000. Legal representation is often used in such cases, as they are often complex in nature. The judge will bear in mind that cases allocated to the fast track will generally require a period of no more than around 30 weeks to prepare for the trial, written expert evidence only, and, if required, a trial lasting no more than 1 day, i.e. 5 hours. These are big cases that are always complex in nature, with big monetary figures and must be more than £25,000. This method takes the most time in reaching a conclusion on a particular case. Legal representation is always likely to be obtained by the claimant and the defendant. We will now examine the civil court structure, and in doing so, we will start with the highest court and end on the lowest civil court. Since joining the EU in 1973, England must abide by the decisions of the Court of Justice of the European Union. The Court of Justice comprises of 3 courts: European Court of Justice, General Court of European Union, and the Civil Service Tribunal. The European Court of Justice answers questions of European law in response to queries referred to it by the national courts and appeals from the General Court. Individual claimants have no direct means to appeal to the European Court of Justice from United Kingdom courts. The General Court of European Union, formerly known as the Court of First Instance, like the European Court of Justice, has jurisdiction to decide questions of European law, but unlike the European Court of Justice, claimants can bring direct actions to the court. Another difference is that the United Kingdom courts cannot refer questions to it. The Civil Service Tribunal is a relatively new court established in 2005. It hears disputes in relation to and on behalf of the European Union Civil Service. The Supreme Court, which came into operation in the autumn of 2009, is the highest court within the English civil system. It is the final court of appeal for all cases. It replaced the House of Lords' power in terms of acting as a judicial court. It was felt that the House of Lords was contrary to the separation of powers. The members of the Supreme Court no longer sit in the House of Lords. The Supreme Court is comprised of 12 justices. The Court of Appeal was established by the Judicature Act of 1873. This court hears appeals from the 3 divisions of the High Court: the Divisional Courts, the County Courts, the Employment Appeal Tribunal, the Lands Tribunal, and the Transport Tribunal. The most senior judge is the Master of the Rolls. Usually, 3 judges will sit to hear an appeal, although for very important cases, 5 may sit. The High Court has 3 administrative divisions: the Queen's Bench Division, the Court of Chancery, and the Family Division. The High Court Queen's Bench Division is the main common law court and is the division with the largest workload. It has some criminal jurisdiction and appellate jurisdiction, but its main jurisdiction is civil concerning contract and tort cases. The Queen's Bench Divisional Court is distinct from the Queen's Bench Division. The Queen's Bench Divisional Court exercises appellate jurisdiction on a point of law by way of case stated from the magistrates' courts, tribunals, and the Crown Court. It also exercises the power of judicial review of the decisions made by governmental and public authorities, inferior courts, and tribunals. The Chancery Division has jurisdiction over matters relating to the sale or partition of land, the raising of charges on land, mortgages, trusts, the administration of the estates of the dead, contentious probate business, such as the validity and interpretation of wills, copyright, company law, partnership, revenue law, and insolvency. The Chancery Divisional Court comprises of 1 or 2 Chancery judges. This appellate court hears appeals from the Commissioners of Inland Revenue on income tax cases, and from county courts on certain matters like bankruptcy. The Family Division of the High Court deals with all matrimonial matters, both first instance and on appeal. Amongst other matters, it deals with issues relating to minors, legitimacy, adoption, and proceedings involving domestic violence. The network of county courts was introduced in 1846 to provide for local adjudication of relatively small-scale litigation. There are currently 243 county courts. The county court jurisdiction extends to probate, property cases, tort, contract, bankruptcy, and insolvency. It has jurisdiction to hear small claims cases under the Small Claims Track, which we have already discussed earlier on in the presentation. The magistrates' courts have a limited civil jurisdiction. They hear family proceedings, and in such cases the court is referred to as a family proceedings court. Importantly, the magistrates' courts have no jurisdiction over claims in contract or tort. In conclusion, the civil process falls within private law. It relates to the balance of probabilities.